the governor should assent. I'm glad your lordships are agreeing.
Maybe advocate
yes,
then.
Mr. Assent is mandatory.
No. Yes, Advocate General. What
Yes,
is your
sir,
article?
unless the learned
1 minute,
advocate-
sir.
yes,
Why is he asking you? Just wait.
How do you get off this article 200, sir?
My lord, the assent, your lordship will please to see that was the very same assent of bills was an issue before the Supreme Court, my lord. Justice Pardiwala said, my lord, in the event, Justice Pardiwala said, in the event that it is held for more than 1 month in certain cases, 3 months in certain cases, it should be deemed that the assent is given. My lord, in this case, assent is given, my lord, insofar as reservations are concerned, at 42% by the.
But you should have said so. You should have said so in the GO itself, no? That we have sent it, we have waited for 1 month. That in view of the latest law laid down by the Honorable Supreme Court, it is deemed assent.
1 month also has not
my
passed.
lord, as far as I know, it is.
This is a precise question we are asking in your support. What is?
Please wait.
1 minute, 1 minute.
My lord, my lord, not mentioning in the GO, my lord, I humbly submit to your lordship that not mentioning in the GO itself, my lord, does not make the GO any infirm, my lord. That's the.
Maybe right. My
lord,
whether that 1 month time is over or not, that is also not over, no, sir. That's all difficult.
Even 1 month is not over.
More than 1 month is over, my lord. We'll make our submission. That's my primary submission.
1 minute. We are not saying anything. In order to understand the case, we are putting some questions. That doesn't mean that we are against you or for them, or they can't say that we are against them or for. Not like that.
Right.
In order to.
In our writ petition, page 84, there's a bill.
My lord, we make a request, my lords, for your lordships to have it immediately after vacation. They cannot.
For AG's convenience, at page 84, we have put the bill in the second writ petition.
Is anyone having the copy of the bill?
Yes, ma'am. Page 84 in the second writ petition. AG can also refer it, learned AG. For your reference, just for reference of all of us. Page 84,
Yes,
exhibit P6.
It's 3 months, my lord, not 1 month. I've read the judgment, it's 3 months.
That is 31st August 2025. This is in assembly. And thereafter, I am told legislative assembly it has taken next day.
yes, this is for local bodies, sir.
Yes,
They have
both are.
sent it. Where is the question of?
It is.
Panchayat is at page 90. Panchayat is page 90. We have not filed local bodies. Municipalities, then Panchayat is at page 90, my lord. Same date, 31/8/2025.
Ayur, let us say.
So 1/9.
It's absurd, my lord, to say that 1 month and then say this is the law. Can it be said like that? And one more thing, my lord, this is what I'm trying to submit to your lordship. The honorable division bench of this court, while holding 34% is not to be allowed, apply the honorable constitution bench.
Yes, argue on this page 94.
Yes,
Yes, let the learned advocate general answer. Yes, Mr. Sudarshan Reddy. Mr. Sudarshan Reddy. This, see the bill, page, you have presented this bill.
Right. There are
Yes,
two bills.
to amend section 285A of the Panchayat Raj Act.
My lord, one bill is
Yes, sir. Governor's assent is pending consideration of governor's approval. Where is the question of going ahead with this?
my lord,
Okay,
my submission before the lordships could be, if it is refused by the government, it stands
No,
on
no,
a,
no.
it stands on a
Where did you
different.
say that? Where did you say that in the GO now? Where is the, see, this is, as a policy decision, you have conducted you have collected empirical data. BC Commission, dedicated commission has conducted inquiry.
Yes.
Population, according to your data, is 53 point so and so. You have decided to enhance reservation to 42%.
Yes.
Yes, you passed a general, you wanted to pass a general law. Bill is presented, unanimously approved by both the houses, pending governor's assent. Where is the question of going ahead with this? How can you issue this GO now?
My lord, in
No,
circumstances,
it has not even become a law now.
in circumstances of this nature, my lord, if the governor refuses, my lord, it stands on
No,
a
no,
different. My lord, I
this
bring
bill
to you.
itself is for amendment of what, this section 285,
Well, that's the reason, my lord.
for
if it-
increasing the cap.
In the event, my lord, the governor were to refuse it, it stands on a different footing. When it is pending with the governor, my lord, I would make my submissions before your lordship.
Show
On the
me,
day or
show-
any day your lordship has. My
please
lord,
show us any judgment which says pending assent of the governor, you can go ahead
this
with
is a house motion.
implementation.
This is a house motion which is moved before your lordship.
This
Me
is
to
only,
argue, my lord, as if it is a final hearing would be a difficulty, my lord.
Mr.
I'm
Sudarshan Reddy,
to stand that.
there was some constitutional restriction because of law laid down by Supreme Court,
No, my lord, even the Supreme
restricting
Court, my lord, even the Supreme Court.
reservation. Please, 1 minute. Because of law laid down by Supreme Court in Indra Sahni's case and subsequent judgments, sealing reservation to the extent of 50%. Now you have decided to amend section 285A of the Panchayat Raj Act 2018. Yes, you have presented the bill. You have sent it for the assent of governor. Governor has not given assent. So where is the question of going ahead just because High Court has, and you say here, Honorable High Court of Telangana, its common judgment dated 25/6/2025, WP number 2661 of 2024 and corrected cases, has directed state government to complete. For the sake of complying with this order, you will now go in a post-haste
Madam, on
manner
that I wish to
and
add,
see pending assent of the government, can you go ahead?
wish to add something. The
things,
direction is to complete the election process, not this process of
One minute.
reservations.
No, 1 minute. You
No,
can
without
have-
the
1 minute,
Supreme-
1 minute. You have two alternatives, Advocate General. You must at least go and file extension petition in that writ petition number 2661 of 2020.
No, that's what I'm clarifying. For a moment before he answers, I just need to clarify.
Filing it
One
on the.
aspect, Advocate General, just a minute. Because the bench never said that await the reservations. Because the Supreme Court said that if the reservation, this thing can't be done, you proceed with the existing
They say so.
list. That is settled law. That is settled law. So therefore, the bench never gave this time to enable them to complete all that exercise. Irrespective of that, they must hold elections.
No, they can seek.
Today,
extension
they
of-
can't
no,
take shelter
one-
from
one
the-
minute. They can file an application seeking extension of time.
That they could have taken, no,
No,
notwithstanding
1
that.
minute. What is the stage of that before the governor? Anybody can throw some light on
That we
that?
probably we
I
cannot.
believe he has sent it to the Honorable President, my lord, for clarification.
What is the stage?
Because it's with the-
with
the President.
What is the stage before?
We can't be saying that.
Huh?
My lord,
No, probably none of us.
No, no, Mr. Vidyasagar, you please inform this court pending assent of the governor when they have passed a bill. Governor's assent is pending. Where is the question of can they issue this GO? Please inform.
Does it become a law?
No, no, you as an officer of the court, you please guide the court. You
Independent of the.
1 minute, yes.
Constitutional mandate.
Can they do this?
There is no reasoning given in the GO.
Forget, please answer our question. Can they do it or not? Our prima facie opinion is they cannot do it. Please tell us.
Unless the president assent is, or governor assent is
Yes,
deemed.
they cannot do it.
There is one aspect. Suppose if you want to really increase to 42%, then file an extension application in that writ petition that is 2661 of 2024, seeking some 3 months' time, so that pending assent of the government, postpone these things. So we'll not comment anything on this. You file an application in the 2661 of 2024, saying that you can seek another 3 months' time in view of the latest judgment of Supreme Court, whether it has become final or not final. Because again, presidential queries are there before the before the Supreme Court, whether
Matter is
Supreme Court can give a directions to the governor and all those things. That's an issue. Now, as on today, 3 months' time is prescribed in your one particular judgment. If it is not given any assent, then it is deemed to be law, right? So you file an application seeking extension of time by 2 months, events are not going to fall. Your decision to increase to 42% also will be sacrosanct. The way you want to do it, you can do it. But it is not even 1 month pending before the governor, no. That's the point.
Wait.
My lord, the whole submission before your lordships, my lord, if your lordships, pardon me, my lord, if your lordships would have it after vacation, our
So that-
submission,
If
my
you-
submission before your lordship.
No, 1 minute. If you want to get instructions, we'll have it tomorrow.
Not tomorrow, my lord, your lordships may have it on the reopening day, my lord. It can't be, my lord, there can't be an urgency in a matter where, my lord, a welfare,
Please,
my lord,
we are not coming in your way in increasing the reservations in respect of BCs from 25 to 42, but do it in accordance with law, no. You go and
we'll bring it to your lordships notice, my lord, we'll satisfy your lordships. My lord, a welfare legislation of the state, my lord, cannot be, my lord, your lordship may pardon me, cannot be interfered.
That goes to the root, no, that goes to the root. Because without there being an enactment, how can you go in anticipation of something?
There are two things, my lord, which I would like to bring to your notice. One, my lord, the amendment which was made, and my lord, the act which was made, the legislative competence of the state is there. My lord, when the legislative competence is
No
there,
doubt, sir, that's there. Your bill is there, it is pending assent, it has not
bring
been.
your lordships, my lord, your lordships may kindly, my lord, legislative competence of the state is not in question. My lord, the legislative competence is there, and that legislation is passed unanimously.
Unless it is accepted by the governor, it will not become the law, no.
My lord, I'll bring that to your
Law
lordship.
to implement.
My lord, in circumstances of this nature, my lord, where there is a legislative competence with the state, my lord, which is clear, and my lord, which is not in dispute that the legislative competence is there, my lord,
Not
a
like
mere,
that, not like that, senior, try to understand.
mere assent of the president or the governor, my lord, is not an issue, my lord. It does not debar the state from making a law accordingly. My lord, a welfare legislation cannot be interfered with, my lord, by way of a house motion, my lord. Your lordship may pardon me, my lord. A welfare legislation cannot be interfered, my lord, by way of a house motion, my lord. Your lordship may hear it, and my lord, your lordship will take a decision on that. Nothing hampers, my lord, between
No,
today
no.
and
1 minute, 1 minute, 1 minute. If elections are not conducted before 30th September, events are not going to fall. You are conducting elections just because of an order passed in petition number 2661 of 2024.
we are very different, my lord, from the honorable courts, my lord. We are very
2 years. 1 minute, sir. There are so many instances, state has come and filed extension application to conduct election.
Right to file it also, my lord.
Right, you can do that. So you can see, because 1 month time is almost over, as on maybe by 30th September, 1 month will be over. You can conduct elections in the month of November after 3 months time, if whatever the law is laid down by the Honorable Supreme Court, right? So after 3 months, you can come up with an argument. We have waited patiently for 3 months. Now that governor has not enacted, so it becomes a law. So if you conduct elections, here in the month of November, 2 objects will be achieving. One, you will be complying the law. This is subordinate legislation. The main legislature, that is 285 itself is not amended. There's a question of acting on this is a question now. Now, you'll be complying 42% also if you wait up to. Have patience. If you want to do something good for somebody, you must wait. You must follow the law. Then nobody can question you. That's the point. Now, what happens is, only for something, you say, yes, we are, no, 1 minute. Only to say, yes, we have given 42%, it is courts who have interfered. Don't say that, because if you want to really extend that 42%, follow the law. Just wait for 2 months, events are not going to fall. Conduct elections in the month of November or December. That's it. By which time you will be complying the 3 months period of latest Supreme Court judgment. And if the governor doesn't give any assent, also, it becomes a law. Then you can act upon.
My lords may kindly have it after vacation, my lord. We would like to satisfy your lordships on that aspect also. My pleading before your lordships is not by way of a house motion, my lord. A law made by.
Suppose election notification is issued, then writ petitions cannot be entertained.
Even
That's
then-
the law of the land.
That's
Only
the
election
problem.
petition, that's
That's
all.
the
My lord, the arguments which are now sought to be put forward by the petitioner saying that it is a constitutional violation, your lordships can look it at any stage. My lord,
No,
it can't be.
once election process starts, we are precluded.
Right now.
Mr. Sudarshan Reddy, when parent legislation is pending assent of the governor. Where is the question of subordinate legislation?
My lord, may kindly allow
No,
me.
please answer this point actually if you want.
That's the very query I am answering, my lord. My lord, two things, my lord. How do you look at a legislation my lord, it's in the constitutional framework. First, my lord, whether there is legislative competence for the state. My lord, the legislative competence. My lord,
You have given reference, please see page 30, you have given reference of pending bill.
That's
It
what,
is
my
the
lord,
bill, based on that bill you are issuing the subordinate legislation.
I'm not, my lord, your lordship may give me an opportunity to make my submission at once.
No, no,
My
you
lord,
please give us assurance, either you defer the election process, if you do not want us to interfere, please give us assurance that you will defer, we will not interfere, but
Not interfere.
You-
We will not interfere with your GO9. Only thing is, if you want to get instructions, we'll have it tomorrow. Just come back.
I mean, tomorrow, my lord, your lordship may have it on Monday, my lord.
No. By then they'll bring in the notification.
Yes.
You have instructions?
Yes, Mr. Sudarshan Reddy, anyhow, Dasara vacations are there. We don't
Yes.
think you will go ahead with the election. You give assurance that you will defer the election process for a period of 10 days. We will hear the matter after vacations.
Well,
Defer the election process.
What
But I
is
cannot, my lord, I
Are you
cannot
issuing
give
any
an.
election notification? Are you issuing any election
The
notification?
moment the state government gives a concurrence, I have to issue the notification.
When
Deadline
they are
is
going,
30th
when they are giving the concurrence?
Right, when they give the concurrence.
No, can you wait for up to 6th?
But as per the mandate given by the Constitution and the Panchayat Raj,
No, no.
I am required to conduct.
1 minute,
the
sir. Advocate General, you are not coming in your way of enhancing the reservation. Follow the law and do it. This kind of thing, suppose if we stay this or set aside this, then it becomes a problem. The purpose for which you have undertaken so much of exercise by appointing one-man commission and all those things, and that effort made by that one-man commission will all go in waste. You must also understand. So, you get instructions that you are not going to act till 6th, then let the regular bench hear the case, because your object appears to be very noble, depending upon the population, you want to increase and all those things. Maybe that is the policy of the state government. But it should be enacted first. Last 285A has to be amended. Then you can do whatever you want.
And the
My lord,
judgment rendered by.
1 minute, sir. What is it?
May I just say something on facts now?
my lord,
Something on facts. This is the Advocate General and also the election, my friend. Last-
my lord, I have not been asked. My
I'll just say something, then
question-
Advocate General can respond. Mr. Advocate General, just a minute. Lord, whenever we were requesting the election commission to go ahead with the election process, their stock answer was that unless the state government gives us a concurrence, we cannot do anything. So if they can defer the concurrence till for a week's time, nothing is going to happen.
Let the regular bench decide. As a council.
Because
you
election
did- one
commission
minute,
awaits
one
the
minute,
concurrence
one
from the
minute,
state
one
government.
minute. As a council, you did not give any undertaking. You get instructions, if you want, we'll hear the case after 15 minutes or 10 minutes, so that you can get your instructions from your respective clients. Then take a
They
decision.
need to make arrangements and get concurrence.
My lord, before that, my lord, to the queries put by your lordship, my lord, I was
Government
not.
will have to make arrangements.
My lord, to the query put by your lordships regarding, my lord, the assent is necessary or not, my lord, your lordships are asked me a query, I did not even answer it, my lord, everybody is picking up in the middle. My lord, my contention before your lordship says, one, it is always legislative competence. My lord, legislative competence of the state is not in question by the petitioners or by anybody. The legislature unanimously, my lord, I did not complete, my lord.
What if the government returns?
Yes.
Yes, please proceed. Sorry for interfering.
But the legislative competence is not in question. The legislature unanimously passed resolution, my lord, to increase it to 42%, my lord, 1. My lord, insofar as amendment of 285A, my lord, it is pending assent with the governor, 1. True. My lord, when there is legislative competence, a mere pendency does not debar from the state to act in pursuance of its legislation is my contention before your lordships, which I would like to satisfy your lordships on the reopening day or any other day. My lord, it can't be, my lord, even in Krishnamurti, I'll just read one paragraph in Krishnamurti. My lord, Krishnamurti, we have appeared and appeared before this honorable court. I'll just read one paragraph of Krishnamurti, my lord. While 50%, I'll just read it for your lordships. While 50% shall be the rule, it is necessary not to put
Please see.
out of.
One minute, sir, what is this kind of argument? We are hearing Advocate General, you are disturbing.
I am absolutely at a loss.
Yes,
My lord,
please.
while 50% shall be the rule, it is necessary. It is
Which-
necessary
which-
not to put out of consideration certain
which-
extraordinary situations inherent in the great diversity of this country and the people. It might happen that in the fixing and remote areas of the population, inhibiting those areas on account of their being out of mainstream of national life and in view of the condition peculiar to and characteristical to them, need to be treated it in a different way. Some relaxation of this strict rule may become imperative. My lord, these are various contentions which we could try to raise before. There is no hard and fast rule. My lord, insofar as this state is concerned, it is this situation where empirical data is there was never considered by the Supreme Court
Yes.
at any point of time.
Mr. Sudarshan Reddy,
50%.
you have decided to amend section 285A. You have presented the bill. Bill is passed. Pending assent of the government, can you
Government.
may go for a subordinate legislation? That is the point involved here.
Yes,
You
my
have
lord,
decided. Can you do that? No one is questioning legislative competence. That stage has not come here.
and my lord,
Now,
if it is kept
You have chosen, you did not go for subordinate legislation directly. You have chosen to amend 285A. Amendment has not taken place. Pending amendment, where is the question of issuing GO? How can you go beyond your,
As of now, if you want, you can get instructions from your state, whether it can differ up to 6 is a question. Then, and also take a decision whether elections can be postponed. Only thing is you'll have to file an extension petition.
That's what I wanted to clarify, Lord. They need not even use the words postpone. Lord, if they don't give concurrence till 7th, that's enough. Lord. Because today the steps are that the election commission will send them a letter. Then they will have to say that all arrangements are made and we are giving concurrence. And today, Lord, this 42% is reserved. Lord, they will also, actually speaking, they require some time. Which particular case, which particular seat will go to SC, which particular one will go to BC. It takes time. This is what they have been saying when we have approached the Supreme Court. Your lordships were part of it. And then the election commission said, we can't do anything unless the state government gives a concurrence.
Consent.
So today that consent and concurrence, it can be it can be postponed till 7th for a next 1 week period. That's enough, my lord.
have it on any day, my
We are
lord.
not postponing the elections.
I can get my
Postpone it for 2 years.
Please get instructions, Advocate General. We are not coming in the way of your noble cause of enhancing from 25 to 42 or whatever you want to do. Do as per the law, that's it. It's a matter of only 2 months or maybe 1 month. For the present, since it is a house motion, you'll have to get instructions, don't do anything till 6th. Next.
Lordship, may I have it on any day, my lord. I'll get my instructions. And so far, my instructions are concerned. Apart from instructions, my contention before your lordship.
We have heard, that's a route that goes to the court to Advocate General. Try to understand.
Lordships, my lords, even if the assent of the governor is not given, my contention before your lordships that in view of the legislation, we can go along with this.
No,
Apart
that
from
is,
that,
Your lordships may decide the matter on that aspect.
your lordships may want us to get
He
instructions.
wants-
Get instructions. Any day, your lordships.
We have difficulty in,
so you are forcing us to pass stay orders. What is it?
No, my lord, your lordships may have the instructions on any day and for the purpose of instruction.
No, right now you can get instructions. What is it?
please get instructions within
5-10 minutes.
15 minutes, 5-10 minutes, because
No, I try to contact them, my lord.
Yes.
you give some undertaking that the election process
Yeah,
will be deferred by 10 days, that's all.
I'm
So
not
that,
giving any undertaking, my lord. I'll call my lord, the secretariat and find out, my lord. I can't give any.
Yes, please, find out and give
We are
undertaking.
not asking you to give any undertaking.
I'll find out.
perhaps I am stretching myself and saying that even undertaking, they may only say the process will take some time. That is enough.
1 minute.
For a week's time. That will take care of.
Yes, Senior Vidyasagar sir. Law is very clear on this subject. Until unless 285 is amended, they can't do anything. The Parent Act should be then the question of subordinate legislation would arise.
So,
So, only thing is they'll have to file an extension application in the 2661 of whatever
For
case.
learned single judge.
and what is there?
That's only,
Procedural.
that's a procedural.
Procedural. Because
So that-
under the act, unless they give a concurrence, I cannot be compelled to conduct the elections.
That's what I
And there
said.
is a necessity because
Act on, act itself
Don't
says.
hurry things so that you end up into legal issues, legal problems.
because the elections were held in 2019, long back.
2 years is, so many years pending to.
Oh,
10
so many
years.
writ petitions we have argued before the learned single judge to expedite.
It's been pending
So,
for
The
years.
petition orders are in before a single judge.
Before the single.
His lordship also sitting single judge, municipalities matter came before your lordship. Panchayat matter came before the other
Both
bench.
municipalities and panchayats elections are.
Simple petition for extension.
Yes, that's, any other advocates who want to add that, advocates who are supporting BC cause, that's a
Yes,
good cause.
may-
That goes
may-
through- Yes,
May I submit, my lord? I am Prabhakar Chittoor.
you can say so, some things, till Advocate General gets some instructions. Yes, you want to add anything?
Lordships, with
I only
great
wanted
respect
to add one thing before my friend reacts, sir. Probably you would not have heard. It's not as if the quota as BCs is being challenged here. The challenge here is, if you take this, if you implement this, you exceed 50%. That's our problem. Not that the X community is given more or Y community is given
That's a
less.
different thing.
That's our
My
thing.
lord,
That's the problem
may
today.
may I say one thing, my lord?
Yes.
If you're with your lordship's permission, may I say one thing, my lord? May I say, my lord?
Anyway, till Advocate General gets instructions, we can hear you.
My lord, there is no such a Lakshmana Rekha, my lord, that the 50% cap should not go beyond it.
Okay, that's not an issue here. What we have
Yes.
argued, the 285 amendment is pending before the governor. And
Yes,
before
yes, yes.
consent being granted, can the state government go ahead with this? Is the only question that goes to the.
It appears, my lord, that March 30th was the day when that was sent to the governor. March 30th, it appears, my lord, it's subject to the correction by the learned Advocate General. What we have learnt is that was sent on 30th of March. So therefore, it is almost,
31st August, not March. 31st August. Next.
May I submit, lordships? The learned senior council has been appeared before your lordship that they didn't challenge any rules.
ఈ లీగల్ పాయింట్ కి
statutes.
చెప్పండి సార్ 1 minute ఈ లీగల్ పాయింట్ కి చెప్పండి until unless 285 is amended it is pending for governor how can this fine get
Allow me to 1 minute, lordships. Allow me
Yes.
to 1 minute, lordships. The learned senior council appeared before your lordships by challenging the GO. Neither they challenged the rules or any statutes or any constitutional validity of acts, lordships. And under these circumstances, with great respect to this honorable court, with great concern to this honorable court, writ rules 14A sub rule 6 has categorically stating that, my lord, this matter would go to the learned single judge. With great respect to this honorable court, with great concern to this honorable court, I may be permitted to read it that 14A Roman
1 minute
6
sir 1 minute sir we are not hearing this case on our own this is allotted by honorable chief justice as a master of roster so our hands are tied okay don't argue all those
But
things. Next.
rules are in force.
Okay, forget about all this. You can go and complain to the chief justice. Why he has
I am
questioned?
very sorry, my lord, so that I said that with great respect to this honorable court, with great concern to this honorable.
Mr. Prabhakar, 1 minute, 1 minute.
Obliged, obliged.
Any other counsel? So many persons are online. Nobody is saying anything. Feel Advocate General because we are getting bored. You must say something, no? Yes, Ramesh.
Yes. If you see the amendment also.
Yes, we have seen that.
No, No, the proposed amendment also
94.
says that we will make it in tune with the demographic requirement. But then they they can't get away with that Supreme Court judgment which said we above 50% cap.
You will see.
My-
this.
My lords, this is Ramesh Chilam.
They have mentioned this
Yes,
bill in
that-
the
this is
GO.
the
Where
first-
is the,
This is the first hurdle.
And proportionate reservation. for
where is the
BC
question of issuing this GO, awaiting the assent of the government?
This is the first hurdle. The next hurdle is
Let
that
them crack this hurdle first.
legislative has taken care of it. See that they don't get out, they can't get out the 50%.
Yes, any council.
And what learning
One
education
way-
was reading
My lords, this
was
is Ramesh
summarized in the
Chilam.
last para, not the same
Actually,
judgment. The
my
last
lords,
para-
actually,
And since
the
19
state government, my lords, by way of
No, no,
the
that is-
ordinance,
that was online, no? They-
July
they want to add a
15th.
point.
2 World Cups have gone by.
1 minute, just 1 minute. Councils are appearing online. Still, Advocate General get some instructions if you want to add anything. These are basic legal issue we have raised.
Yes.
Without amendment
And-
to 285, anything, anybody wants to say anything, you are entitled to say.
On legal issue, Milord, which my learned senior counsels were referred judgment, Vikas Kishan Rao versus State of Maharashtra, 5 judges bench judgment, Lordships. Para 63, I may be permitted to read it, Lordships.
Read.
As noted earlier, social and economic backwardness does not necessarily coincide with political backwardness. In this respect, the state government are well advised to reconfigure their reservation policies, wherein the beneficiaries under Article 243D subclass 6 and 243T subclass 6 need not necessarily be contemporaneous with the social and economical backward classes for the purpose of Article 15(4) or even the backward classes that are underrepresented in the government jobs. For the purpose of Article 16(4), it would be safe to say that not to all of the groups which have been given reservation benefit in the domain of education and employment need reservation in the sphere of local self-government also. This is because the barriers to political participation are not of the same character as barriers that limits access to education and employment.
Prabhakar, you are not understanding why you are reading that. Try to understand. The state government, what it says is, it intends to amend 285 and it has submitted that bill before the governor. Governor has not given
He's reading
access to that particular bill. Until unless he gives assent, it will not become law. If it is not law, it can't be implemented. That's the only question. Please answer that. That's only, that goes to the root.
My lords, may I add, my lords, with lordship's permission, my lords?
Lordships,
Actually,
one sentence I can complete,
Can-
Lordships. Ramesh Okan.
Oh, sure.
This calls for some fresh thinking and policy making with regard to reservation in local self-government. This is my humble submission, Milord.